to get his son back from Brazil. He did it with great class and strength and has been an inspiration to so many of us and also an inspiration for the law itself. And so many others, many of whom are here today, have played an outsized role in trying to ensure its effective implementation over the last 10 years. And so I want to thank all of them for being here today, because it certainly does make a difference. We do know that there's the heartbreaking reality is that hundreds of American children are still abducted each and every year, illegally kidnapped by one of their parents to a foreign land. They are subjected to what is child abuse with devastating psychological and even physical consequences for them and their families who have been left behind. We all know it's called parental alienation, but the term doesn't even begin to suggest the devastation that that child and the family and the left behind parent do experience. Although a number of abducted children and cases have gone down, the rate of return actually has worsened. Fewer children are abducted. That's a good news story, but fewer of those abducted children actually come home. The questions that remain are, what is the U.S. government doing to prevent international parental child abduction, to hold Hague Convention violators accountable, and to bring American abducted children to home? Today, we will hear from the U.S. Department of State, officials responsible for implementing the Goldman Act, family law attorneys and Hague Convention experts, and a parent and a child who have personally experienced the heartbreaking pain of separation and abduction. The Goldman Act empowers the State Department to use the full range of diplomatic tools prescribed in the law to seek the return of abducted American children, from a démarche or public condemnation to delay or cancellation of bilateral visits or an extradition request. Annual appropriations language also authorizes the department to withhold bilateral assistance funds to the governments of countries that are not taking the appropriate steps to comply on child abduction issues. The State Department could do better. No matter who's in the White House, there seems to be at times a lag. It needs to use the tool, especially the sanctioning tool, which has been given to them, to you. Only once has we gone beyond a démarche. And I say that because I've authored other laws, including our law dealing with human trafficking. And even there, while we have a prescriptive list of very, very serious sanctions, we threaten them and we don't do it. So after a while, countries that are out of compliance take note of that, and they say, well, it's more rhetorical and embarrassment rather than any kind of tangible impact. So I admonish you, ask you, plead with you to use that tool, those tools, those sanctions, obviously in a judicious way, which I know you can do, to hold these countries to account. The Hague Convention, enforced between the United States and some 80 foreign countries, says that countries must expeditiously return abducted children, quote, wrongfully removed in violation of the left behind parents' custody rights, to their state of habitual residence. The State Department's annual report names 16 foreign nations as having, quote, demonstrated a pattern of non-compliance in 2023. Argentina, Belize, Brazil, Bulgaria, Ecuador, Egypt, Honduras, India, Jordan, Republic of Korea, Montenegro, Peru, Poland, Romania, Russia, and the United Arab Emirates. 6 countries, Argentina, Brazil, Ecuador, India, and Jordan, and Peru, have not been complicit 10 years in a row. What a horrific record that is. Recent annual reports have removed Japan from the list of non-compliant countries. I do think that's a mistake. And Japan has made some legitimate progress, no doubt, in recent years, passing legislation to strengthen enforcement of court-ordered returns. Just this spring, the Japanese Diet passed a law allowing for dual custody, and we've been pushing for that for 10 years. When we first started this effort, I was shocked to learn that that's something that was not on their books of law and jurisprudence, and now it is. Yet in other ways, Japan must improve its disturbing track record. More than 500 children have been abducted to Japan since 1994. When Japan acceded to the Hague Convention in 2014, there were still more than 50 open pre-Hague cases of abduction to Japan. Today, all but 4 of those cases have been resolved or closed. What happened to the children? How many pre-Hague cases of parental child abduction were actually resolved in a just and satisfactory way with the child's return to his or her left behind family. It is very unclear, indeed. It appears that most of these children simply aged out of the system. When the child turns 16, Hague Convention protocols and State Department reporting ceases to apply. In addition, left behind parents report extreme difficulty in obtaining rights of access, especially in pre-Hague cases. What is the State Department doing to convey to foreign governments the importance of fulfilling their Hague obligations under international law? Are we trying to sign bilateral MOUs with non-Hague countries and with Hague countries that still have open abduction cases that precede that country's accession to the treaty? Another question I intend to raise deals with the limited exceptions to the Hague Convention's rule of expeditious return. The 8th meeting of the Special Commission of the Hague Convention has stated that, quote, while the exceptions derive from the consideration of the interests of the child, they do not turn the return proceedings into custody proceedings, close quote. Yet in some countries, untrained or unwilling judges relitigate custody rulings instead of strictly applying the Hague Convention. What has the department, with all respect, and if you could answer this, done to address that problem? I'm eager to hear from our very distinguished witnesses today, beginning with Robert Koepcke. I told you I'd get it wrong. Deputy Assistant Secretary for Japan, Korea, and Mongolia, and Michelle Bernier-Toth, Special Advisor for Children's Issues. According to the annual report, finally, in 2023, there were 721 open active abduction cases involving 982 children, as well as 69 open access cases involving 92 children. Only 205 abducted children out of 982 were returned to the U.S., so we have to do better. Hundreds of cases tragically remain open, and a further 227 inquiries were made by families that did not complete their Hague application or provide related documentation, indicating that the true number of child abductions from the U.S. is likely far higher than we think. These children, of course, are gifts. They are precious, not only to their families, but also to our country, to the United States. And most children desire a relationship with both parents. They don't want to be forced to pick between them, which is exactly what an abducting parent does. These children have the potential to be a bridge, even, for friendship between the two countries. They serve as bonds and symbols of trust and friendship to both their countries of origin. So I would urge you, I have introduced a new bill called the Short and David Goldman Child Act Amendments. It strengthens key aspects of the Goldman Act by requiring disaggregated data and increased transparency from the State Department, raising the age of the child from 16 to 18, and funding research into the lifelong trauma that studies and testimonies suggest is caused by international parental child abduction. During our second panel, we will hear testimonies from left behind parents. One who founded one of the leading U.S. advocacy groups on this issue, a child survivor of international parental child abduction, and a family law Hague Convention expert to discuss the ongoing challenges. So I look forward to their very, very important testimony. Jeffery Morehouse, I would just point out, thank you for being here, for being absolutely tenacious on behalf of your child. We have met maybe 50 times. You have testified before in a very, very civil and strong way. I wish Japan would take note of your appeal. It is so well-founded in justice and in good law, but to date they have not. So we make that request again to the Japanese government. I'd like to now yield to my good friend, Ms. Wild, for any opening.
Thank you, Mr. Chairman, and thank you to all of our witnesses and the audience participants for appearing here today. When I first ran for office, I'd often say to people that I was getting in this for my children and staying in it for yours. And as members of Congress and as public officials more broadly, I believe that we have a particular and special duty to do right by children and the most vulnerable members of our society. As a parent, the idea of being separated from my children when they were young would have been unimaginable. Heck, I could hardly deal with a workday separation. And I don't mean to make light of it. I just can't even imagine extended separation from one's child. To all of those who have had to endure this unthinkable hardship, including the courageous advocates in this room, please know that we stand with you. I want to take a moment to recognize multiple constituents of mine whose children have been abducted to Egypt. While the circumstances differ across each case, they all highlight what I believe to be a lack of sufficient coordination between the State Department, the Department of Justice, and local and state law enforcement. I hope we can address the need for greater coordination during this hearing, and that those of us in Congress, Republicans and Democrats alike, can work together to push for solutions. Advocating for children, including international parental child abduction cases, must be a cornerstone of our foreign policy. These cases are sensitive, complex, and difficult. Parents, legal guardians, and other American relatives depend on missions abroad to raise these cases with foreign government officials at the absolute highest appropriate levels, and to ensure that the foreign government understands that the U.S. government's concern for the welfare of its citizens overseas, particularly children, is paramount. Pursuant to the Goldman Act, the State Department continues to improve strategies for U.S. government engagement with numerous countries on international parental child abduction. As members of Congress, we must continue to ensure that we are providing a whole-of-government approach to combat and resolve abductions, and that we are employing strategies that are tailor-made to be effective within the political, cultural, and institutional conditions of any given country. Civil society advocates, legal professionals, and other stakeholders play a key role in advising and informing members of Congress and our diplomatic corps on the complexities of these cases. We must continue to strengthen cooperation to ensure countries that are in non-compliance with the Hague Convention are not only aware of these issues, but act to change their laws to be in compliance with the convention. If countries refuse to do that, if they refuse to improve their laws in accordance with international standards, including as stipulated by the Goldman Act, then we have a duty to hold them accountable. I will always stand ready to work with anyone of either party on behalf of these children and their families, both here at home and across the globe. Thank you, Mr. Chairman. I yield back.
Thank you very much for your very fine statement and your leadership on this issue. I'd like to now recognize Mr. Keating.
Thank you, Chair Smith and Ranking Member Weil, for holding this important hearing today. The issue of international child abduction demands our utmost attention, and hearings like this help bring the important light to bear to the Hague Convention violators and the victims of this horrific crime. Today, I'd like to speak briefly on behalf of my constituent, Michael Fallon, whose son was abducted from the United States last year to the Republic of Korea. For more than a year, Mike's been working tirelessly to secure the unlawful return of his son, who continues to be held unlawfully by his mother and her family. He secured favorable decisions from the courts in Massachusetts, and most recently, the Hague Convention Court in Korea ruled in his favor as well. While his case is still going through the legal process, the Republic of Korea has an obligation to expeditiously conclude the legal proceedings, and I'm hopeful they'll do so. With Mike's case in mind, in March, I wrote the Korean ambassador to the United States regarding Korea's multi-year noncompliance with the Hague Convention. Specifically, Korea remains unable to effectively enforce Hague Convention rulings, which are significant steps towards ensuring the safe return of abducted children. I believe this hearing helps make clear to the Korean authorities that the United States will do all it can in compliance with its Hague Convention obligations to ensure the safe return of all children. The Republic of Korea must do the same, and I'm hopeful that the Korean government will take the necessary steps to ensure their full compliance and significantly update their enforcement procedures. I want to thank Chair Smith and Ranking Member Weil again, as well as all our witnesses for being here today. Your continued engagement with partner governments and communications with families and victims impacted by this devastating event has never been more important than it is today. I yield back.
Thank you. Ms. Manning. Thank you. I'd like to now introduce our two witnesses, and again, thank them for being here and for their leadership. Beginning with Robert Koepcke, who's the Senior Foreign Service, a member of the U.S. Department of State, currently as Deputy Assistant Secretary for Korea, Japan, Mongolia, and the Bureau of East Asian and Pacific Affairs. Previously, he served as Director of the Office of Mainland Southeast Asia, as well as Director of the Executive Secretariat Staff in the Office of Secretary of State. He served as the U.S. Consul General in Okinawa, Japan, during 2018 to 2021. As a Special Assistant to the Undersecretary for Economic Growth, Energy and Environment, Robert developed an economic pillar of the department's quadrennial joint strategic plan, 2017 to 2022, before which he was Deputy Economic Section Chief at the U.S. Embassy in Berlin, Germany. Robert was detailed to the National Security Council during 2012 to 2013, where he was Director for Japan and Asia Regional Affairs. As Deputy Director of the Office of Economic Policy, or EAP, he played a central role in the U.S. host year of APEC 2011. He served overseas tours in Beijing, Baghdad, Tokyo, and the American Institute in Taiwan, Taipei. He holds a master's degree from the London School of Economics and a bachelor's from Boston University. He enjoys introducing American culture through his love of playing and appreciating jazz music. He is married with 2 children and speaks Mandarin, Japanese, German, and Spanish. English will be preferred today, by the way. We'll then hear from Ms. Michelle Bernier-Toth, who joined the State Department in 1987, served consular positions in Damascus, Syria, Doha, Qatar, and Abu Dhabi, UAE. She also served in the foreign service positions in bureaus of Near East Affairs and Consular Affairs, as well as the Foreign Service Institute before converting to civil service in 2003. As a civil service officer, Michelle was the Deputy Director in the Office of Children's Issues, as Director of the Office of American Citizen Services and Crisis Management, and as Managing Director of the Overseas Citizens Services. In December 2019, she was named as the Special Advisor for Children's Issues in the Bureau of Consular Affairs. She graduated from Yale University in 1982, with a Bachelor's of Art in Near Eastern Languages and Literature, and has a Master's in Arab Studies from Georgetown University. She has 3 adult children, of whom she is very, very proud. I would like to now yield to you, Robert.
Mr. Koepcke, right?
Yeah, Mr. Koepcke.
Chairman Smith, Ranking Member Wild, and distinguished members of the subcommittee. Thank you for the opportunity to speak today about the department's efforts on international parental child abduction as it relates to Japan and the Republic of Korea. I appreciate the work you've done over many years to reunite families, and I truly appreciate the efforts of the many parents in the audience today to advocate for this issue on a global scale. As Deputy Assistant Secretary for the Bureau of East Asian and Pacific Affairs, I am deeply committed to protecting U.S. citizens in Japan and the ROK, and to promoting the interests of the American people in the Indo-Pacific region. I want to assure you that international parental child abduction is an important part of our broader foreign policy in the Bureau of East Asian and Pacific Affairs. Together with our consular colleagues, our Bureau has pursued a strategy of persistent diplomatic efforts, legal collaboration, and public awareness to prevent future abductions and ensure the expeditious return of abducted children. We have consistently advocated on behalf of U.S. citizens in bilateral engagements, including on international parental child abduction cases, and will continue to do so at the highest levels. We are dedicated to bringing abducted children home and preventing future cases. Over the last 4 years, we have made progress in Japan and the Republic of Korea. After Japan ratified the Hague Convention in 2014, it lacked strong enforcement mechanisms. Intensive bilateral engagement convinced Japan to enact new legislation in 2020 that strengthened its ability to enforce convention court orders. Since 2021, Japan has successfully enforced returns of children in every U.S. Hague case in which the Japanese courts ordered one. With regard to pre-Hague cases in Japan, the State Department raises them regularly and at senior levels. In 2020, our governments undertook a comprehensive review of pre-Hague cases and committed to hold regular consultations on them. Almost half of the pre-Hague cases that resulted in a successful return or contact involved voluntary agreements reached through mediation and open dialogue. So we have emphasized the importance of mediation as well as prevention. Most recently, Japan's Diet revised its civil code on May 17 to allow divorced parents the option of joint parental authority. This will take effect in 2026 and aligns Japan with most countries around the world. We will closely track the precedents set by Japanese judges and how it will affect left-behind parents on pre-Hague cases. We have also begun another comprehensive review of pre-Hague cases to show our commitment to successful returns. With regard to the Republic of Korea, we cited them as non-compliant in 2022, 2023, and 2024 for failure to enforce return orders. Under the Korean legal system, international parental child abduction cases are not criminal cases, but civil cases. The enforcement officers, who are called bailiffs, are semi-independent entities and not subject to direct orders from the Korean Supreme Court or the Korean Central Authority. Enforcement is reliant on these bailiffs, who have a great deal of autonomy in their decision-making and do not answer directly to judges as court officers do in the United States. U.S. officials in Washington and Seoul have persistently raised these enforcement issues at the highest levels. As a result of our advocacy, the ROK established an international task force in June 2023. The Supreme Court of Korea subsequently implemented new guidance in April 2024 aimed at aligning bailiffs with their Hague enforcement responsibilities. Since then, the ROK has enforced 2 court-ordered returns, including one that was pending for multiple years. Even with this new guidance, we continue to have frank discussions with the Korean Central Authority and the ROK government to ensure bailiffs receive appropriate training, to address the independence that bailiffs have under the Korean legal system, and to grant the police more tools to locate an abducted child. In conclusion, we have made significant strides in our bilateral efforts with both Japan and the ROK, but there is still more work to be done. Addressing international parental child abduction requires a concerted effort of all stakeholders, including governments, legal authorities, and civil society. We are committed to leading these efforts and ensuring that every child is returned home safely and swiftly. I look forward to working with this esteemed committee, anti-international parental child abduction advocates, and our international partners to uphold the rights and well-being of children around the world. Thank you for the opportunity to testify today, and I'm prepared to answer any questions you may have.
Thank you so very much for your testimony. I'd like to now recognize Ms. Bernier-Toth for her testimony.
Chairman Smith, Ranking Member Wild, distinguished members of the subcommittee, thank you as well for the invitation to speak about our work on an important issue that is important to all of us, that of international parental child abduction. I have submitted a written statement to the subcommittee, which I asked to be included in the record.
Objection, so ordered.
International parental child abduction hurts children. It hurts the left-behind parents. It hurts extended families, friends, communities. We know this from the lived experience of adults who were abducted as children. We know this from the parents, the grandparents, and the families of abducted children who face what often feel like insurmountable challenges in trying to protect their children. That is why I take my responsibilities as Special Advisor for Children's Issues so seriously. As an advocate for vulnerable children, I join my colleagues in seeking to resolve individual cases of international parental child abduction and to promote the 1980 Hague Abduction Convention efficient operation as an important framework for resolving and preventing international parental child abduction. In the past year, my colleagues in the Office of Children's Issues and I have traveled extensively to raise awareness of this issue and promote more effective responses by our treaty and non-treaty partners. Since appearing before you last May, I have traveled to Lebanon, Jordan, Belize, India, Peru, Argentina, and most recently Honduras. In Lebanon, I participated in a conference on international parental child abduction that included government officials, attorneys and judges, social workers, non-governmental organization representatives, and foreign embassy officers, and which has led to follow-up meetings and dialogue among stakeholders. In India, I met with judges, attorneys, and Indian officials in the lead-up to our annual consular dialogue. In Argentina, I pressed senior officials in the foreign ministry, civil society leaders, and leadership within the Argentine Congress on the need for Argentina to expedite the resolution of Hague abduction cases. I have met virtually and in person with key officials from Saudi Arabia, Pakistan, and the UAE. In October of 2023, I led the U.S. delegation to the 8th Special Commission meeting on the 1980 Hague Abduction Convention. A key topic of discussion at the Special Commission was the delay in resolving cases in many countries due to the factors we identify in our annual report to Congress: problems locating children, administrative delays in central authorities, slow or drawn-out judicial processes, or problems enforcing return orders. These are some of the issues that we raise when we meet with foreign officials. We have seen some progress on key fronts. In April of this year, the Korean Supreme Court did issue the guidance to give law enforcement officers more authority to carry out return orders. My colleague from the East Asia Pacific Bureau has talked about that. We have started regular meetings with the Indian government officials to discuss issues of mutual concern, including international parental child abduction, and to encourage cooperation on resolving existing cases and preventing new ones. The Sean and David Goldman Act called on us to do more with our military colleagues. In the past year, the Office of Children's Issues has conducted outreach to and training for military attorneys and community officers, who are often the first to recognize when a military family is struggling and an abduction is possible. The Act also called for regular interagency meetings to coordinate preventive efforts. In the past year, we have held 2 such meetings, which foster even closer collaboration between interagency partners. The Prevent Abduction program carried out with the Department of Homeland Security is one of the few and best ways we have to stop children from being abducted from the United States. In the past year, our prevention branch has spoken to thousands of concerned parents, attorneys, and courts to assist them with preventing a child being removed overseas, sometimes with just hours to act. We continue to build on our successes and our work across the interagency to establish a robust and comprehensive prevention program that is flexible and responsive. We know that any forward progress is still too slow for the children and parents affected by international parental child abduction. Every day matters, and too many cases stretch out for years. I stress this point in my meetings with foreign officials to emphasize the human cost of delays that could have been prevented. I applaud the efforts of left-behind parents to raise awareness of the pain they and their children suffer when the child is abducted. Our annual report to Congress under the Sean and David Goldman Act is part of a year-round activity that includes the development of country-specific action plans, collection and assessment of data, consultations with colleagues across the department, and ultimately preparation of the report itself before this cycle repeats. Following a release of the report, we ask our embassies in those countries that have been cited for demonstrating a pattern of noncompliance to notify their host governments, explain the basis for the citation, and press for systemic change. I often follow that meeting with senior diplomats in Washington and always emphasize that this is an issue Congress cares about. I hope that as members of Congress travel and interact with foreign government counterparts, they make the same points. It is important that we work together on behalf of children and families. They are our shared constituents. Thank you again for all you do on behalf of these vulnerable children and for your support for our efforts. I look forward to your questions.
Thank you so very much for your leadership. And just a couple of questions to start off with. When the Prime Minister of Japan was visiting and obviously was so well received by the Congress and by the President, when he had his after speech meeting over in the Rayburn Room, I gave him a letter, talked to him briefly, but gave him a letter on behalf of the left behind parents in Japan, those who were left out when the Hague was signed and ratified. My concern has always been, and it was as, you know, that what a cruelty to those families to say, now we're going to get it right, or at least get on the path to getting it right. But meanwhile, all of these other families, like Jeffery, who's here, Paul Toland, and so many others, are just left out, not being able to see their children, and certainly not having the reunification that is warranted by the law and by, really, universal justice. I gave him the letter. I'm going to put the letter in the record. I'll give you a copy again. We still haven't heard back. And it's troubling in the extreme, with all the diplomatic niceties that he was afforded, and he was very well received, and I deeply respect him as well, that when a very serious set of issues are raised about very real people who are being treated so cruelly, it's just, they rejoiced when the Hague was signed into law, but it was a very bitter rejoicing because they knew they were left out, grandfathered out rather than in. So I would ask you if you could, with the Prime Minister, with the Japanese government, to reiterate an effort, reignite that effort to get these children home. It baffles my mind. Justice delayed is justice denied. There's no statute of limitations on justice, and certainly this injustice and the cruelty of it is just mind-boggling. As my ranking member said, she has no idea how she would handle it. I have no idea how I would handle it as a father of 4 and grandfather of 8 if such a thing were to happen. It was just, it's mind-boggling, not knowing, even when the nuclear problem occurred, many of our left-behind families were trying to find out, was their child in any way injured or put at risk during that crisis, and it was crickets, nothing. And I just find it appalling. So I would put this letter in the record, but I'd like to convey to you a copy again and see if you could at least get an answer. My hope the answer will be, hey, let's just do this. I care about the abductions that have occurred big time. I was on Congressman Honda's bill of the abductions that were going to North Korea. Well, abductions is a two-way street. We don't want any abductions. So I appeal to you to take that back. I do hope you can put even more benign pressure on that government to do more now with these cases. They can't be forgotten anymore. Secondly, I wanted to ask you, with regards to the démarche, and we've had démarches, and when I wrote the law, I patterned it after both the International Religious Freedom Act and the Trafficking Victims Protection Act of 2000. The idea was that you have a very real sanction, like a sword of Damocles hanging over a country for noncompliance. But we know that when it's not used, the country and the bureaucrats in each respective country say, we can weather a little criticism, but there's nothing that's going to follow. When I was fighting for David Goldman so very, very hard, one of the things that I raised on my many trips was that we're going to look economically to taking away GSP, which you need very badly in Brazil. We were serious about denying them the continuance of generalized system of preferences for their products. All of a sudden, they're all eyes. Okay, what do we got to do? Please, you've got economic pressure and other pressure just staring us in the face. That's why we wrote it into the law. 10 years later, blow off the dust, and I appeal to you again to start demarching. No, start sanctioning countries, and we will see results across the board because they'll say, oh, the Americans mean business now. They're not bluffing. And I do think, despite when you're interlocutors, you probably talk to a lot of very good people who care deeply, but they're not making the decision necessarily in country X, Y, or Z. Somebody else is who's saying, just talk, produce on some things. But again, some of these left behind parents that go on for decades, they need a resolution. So I would ask you, if you could, will you be looking to use the sanctions prescribed in the law going forward?
Thank you, Congressman Smith.
Yes.
Each year, the Office of Children's Issues, the country officers, the branch chiefs, the division chief, me, sit down with our colleagues from the regional bureaus, with our colleagues at embassies and consulates abroad, and we review the list of tools in the Goldman Act to see which ones are going to be effective in trying to address some of the challenges we've seen in individual countries. I can assure you that we look at the entire list, and then beyond that, because in addition to what's in the law, we have other tools at our disposal, not just diplomatic tools, but training and things that raise awareness of the importance of implementing the Hague Convention or finding solutions to cases of individual cases of international parental child abduction. So we do look at the entire list each and every year.
But I would ask, and I would appeal to you, that you've got a very serious sanctions that you could impose. And I believe with all my heart, soul, and mind, not only was I inspired by the trafficking law, which I wrote, but more, that was inspired by our civil rights law. Without sanctions capability, the schools wouldn't have complied the way they do and have to. Sanctions do grab the attention. And when you have countries like Argentina, Brazil, Ecuador, India, Jordan, and Peru non-compliant every year since 2015, I met with Modi personally on behalf of a case out of New Jersey. A young woman who had her 2 children abducted, was treated like trash by her now separated husband. He stole from her. The police had reports showing that he was a thief in addition to being an abductor. She went over there and nothing, no help. She was even at risk of court action for trying to see her children. And she's testified here a few times as well. You couldn't find a nicer, more civil, more loving mother who has been absolutely cruelly denied her children. And I brought her to meet with Modi and appealed to him, and nothing happened there either. After a while, you say, these jobs are worthless if you're not willing to help people who are at risk and vulnerable. And so India, one of our great trading partners, allies, we need to do more there as well.
Thank you, and I would agree that India is definitely on one of my top of my list of countries that I've been working on over the past year.
Right. And I have asked before, I'll ask one more time, then yield to my friend, Ms. Wild. Have we tried to get an MOU with India?
We have raised that, but there has been no interest on the side of the Indian government. I think I would note, though, that memorandum of understandings can be helpful in certain instances. For example, we have one that is more operational with Saudi Arabia, which commits both of us to meet on a regular basis to discuss issues. That has been carried out, and that goes on. Other MOUs which have stressed the importance of facilitating parental access to their children, even as the parents seek the return of their child, I would say that's a hit or miss in terms of how we have been able to really use those effectively with the countries involved. So we have to look at it, but we do hold it out as something we will consider.
I would just say, Ms. Koepcke, you might want to answer this as well. We sanction India, we will get their attention. I know there will be other people in the department, there will be bureau heads who will say, oh, don't mess up the relationship. Friends don't let friends commit human rights abuses, and these are against American children and American parents. And with impunity, they are telling us to go, there's this, take a long walk at a short pier, that they don't care. And having had these conversations with people directly, including Modi, he needs to step up, and as does his government, the government. So please use the sanction. You sanction, you will get results, I guarantee it.
Yeah, thank you for that, Chairman. The process that Michelle describes in terms of working together with the regional bureaus and the Bureau of Consular Affairs is something that we engage in on an annual basis, and we'll continue to do so to make sure we're using the tools that are going to be the most effective for getting progress on this important set of issues. For both Japan and Korea, these issues, they're different circumstances, but they remain an important part of our bilateral agenda with both countries. We've been raising it at senior levels and kind of all the way up and down our system, and we will continue to do so. I've had recent active conversations with my own counterpart in Japan on this topic, and you mentioned the letter to the Prime Minister and not receiving a response. I will follow up on that with him because, as I said, we are actively discussing this issue as we continue to see progress.
Ms. Wild.
Seems like it's on. Okay. Ms. Bernier-Toth, as I mentioned in my remarks, I have constituents whose children have been abducted to Egypt by one of the parents over the past several years. I know that Egypt is not a signatory to the Hague Abduction Convention, and that obviously is a significant factor, and I know that you have worked aggressively to press your Egyptian counterparts on this issue, and I would just encourage you to please continue to do that, and please let us know, either my office or the subcommittee, of anything else that you think we can do here in Congress to help you in that effort. One of the problems that we have seen in the cases from my district and in cases across the country is the reluctance of U.S. attorneys to move forward with charges against the abducting parent because a court order was not in place at the time the children were abducted, which is problematic, of course, because an abduction could very well be planned before there's even any known friction, legal experience going on or anything else. And I understand the position of the DOJ and U.S. attorneys, but I also think that that's really hindered some of our progress in this area. And it obviously hinders our ability to press the foreign governments that are in question. And for that matter, it prevents us from being able to ensure that the abducting parent is stopped when they travel elsewhere to third countries or potentially even back here to the United States. So I'm not going to ask you to make comment on the decisions within DOJ, but I'd like to ask you how a more proactive and perhaps supportive approach by DOJ might provide the State Department with some additional authority. And do you, and I'm talking about DOJ and law enforcement generally, and do you see areas where coordination between state, DOJ, and law enforcement could be strengthened?
I think personally, there's always room for more coordination and more cooperation, no matter what the issue is. I'm all about cooperation. I think one of the things we see is that often local law enforcement is not aware that there is no waiting period. If a child is reported missing, that they can enter that child's name into the NCIC.
And when you say
immediately.
local, you mean local as in city?
City, state, local,
Okay.
yes. And so that is an area where I think greater awareness is needed. I mean, certainly we work with the law enforcement authorities on our prevention working group. We have representation there, but again, there's always more that we could do. I totally agree.
Thank you. Do you have any comment on that, sir, about the question I just asked about coordination between state and DOJ and local law enforcement, and what could be done to improve it?
I don't know. I'll just note that in that regard, our consular sections in both our embassies in Seoul and Tokyo work on these issues very closely in coordination with our Bureau of Consular Affairs, and that's where that kind of connective piece would play out.
And so moving on to the challenges with South Korea, Mr. Koepcke, the Republic of Korea was named in the 2024 International Child Abduction Report as non-compliant with the Hague Convention, despite it being enforced between the United States and Korea since 2013. A State Department report to Congress noted that ROK, Republic of Korea, law enforcement authorities regularly failed to enforce return orders in abduction cases. As a result of this failure, 29% of requests for the return of abducted children under the convention remained unresolved for more than 12 months. Do you have any update on Korea's response to the report thus far, and what kind of commitments, if any, have been made to address those findings? And again, that was a report of 2024, just this year, but so I wouldn't necessarily have read of any improvements in their response, but perhaps you know of some.
Yeah, thank you for that question. I think it is a part of the agenda when we are speaking with Korean government counterparts on this. As I mentioned, our post is very much engaged on this. We have outreach to the Korean government seeking progress in light of the non-compliance finding, consistently including from senior officials, including from our technical experts in our consular section as well. I will continue to work with them on that and make sure that they understand where we're coming from on this. As I mentioned in my opening remarks, there are challenges within their legal system. Those are challenges that we've worked with them on to try to find some solutions. And they did push out new guidelines to local authorities engaging on these things. It's not enough, but I think it's clear that we have the channels with the government that we need to have, that we can have these conversations and seek progress. It clearly hasn't been enough, and we'll continue to work on that.
I appreciate that. You know, one thought that I have, Chairman Smith, congressional delegations, known as CODELs, members of Congress travel frequently abroad, often to the countries that we're talking about today and other countries that are cited in the report on child abduction. And it seems to me that we have a duty, because we are often in a position when we're on those trips, to be behind closed-door meetings with the highest level officials, often discussing issues that we care deeply about, sometimes uncomfortable issues. But I can tell you that I have never been, now granted, I have never been on a CODEL to Japan or Korea, but I've never heard this issue raised. And it seems to me that one of the things that we might want to talk about, Chairman Smith, is that every CODEL that is leaving from Washington to go to a foreign country should be educated and advised by our subcommittee or someone else on the instances of child abduction, the lack of any response from that country, and that members of the CODEL should be absolutely encouraged to raise this over and over again. Because, as I said, we often are raising difficult, delicate issues with countries that are our allies, but there are some issues that we care deeply about. But it seems to me that this one is absolutely should be front and center. So thank you. With that, I yield back, Mr. Chairman.
Very much. I'd like to now yield to Ms. Radewagen, and thank you for your leadership.
Mr. Koepcke, Mr. Michael Fallon is another left-behind American parent whose son was abducted to South Korea last summer. While Korean courts have ruled in his favor, the taking parent has hidden his son and has slowed down judicial proceedings through multiple appeals. What has the department done, and what is it doing today to bring Mr. Fallon's son home? And have you raised his case in engagements with Republic of Korea counterparts?
Thank you for that question. I think I am going to turn to my consular affairs colleague for more details. It's my understanding, we don't typically get into specific cases. There are privacy considerations and other considerations. But what I can say is that all of the cases that come to our attention are brought through our Consular Affairs Bureau to our consular section at our embassy in Seoul. So they are tracking these and we'll continue to work on them. And then as we do, as I described, the broader legal framework at work and some of the reforms that need to have to happen there, including possibly legal remedies, are something that we're continue to engage with them on regularly.
I would just add that this and other cases involving the importance of enforcing the return order are of a high priority to not just to our team in Seoul, but to the Office of Children's Issues and, of course, the East Asia Pacific Bureau. This is an issue that we have raised regularly with the government of Korea. And I would also note that the government of Korea has definitely taken note of our annual report. I spoke with them soon after it was released because they had questions about that. So it is the report itself is a useful tool.
Ms. Bernier-Toth, the 8th meeting of the Special Commission on the Hague Convention also stated that while the exceptions derive from a consideration of the interests of the child, they do not turn the return proceedings into custody proceedings. Has the department observed instances of foreign courts relitigating custody issues instead of strictly making the Hague Convention ruling? If so, where? And what has been done to address this problem?
Thank you for that question. That is much of what I do. We often see situations where a family law judge is unfamiliar with their roles and responsibilities under the Hague Convention and, unless advised otherwise, treats the case as a custody case and relitigates those custody issues, which is not appropriate. And so we have emphasized the importance of judicial training and raising awareness among local judges in many countries of their roles and responsibilities under the convention. And we have worked in countries such as, for example, Brazil and Argentina, where I was engaged in this, to work with their Hague network judges to make sure that they are reaching out and they are providing guidance to their counterparts across the country, so that they are better, informed. We have also supported and participated in judicial training for foreign judges overseas to make sure that they know what their responsibilities are. It's a really important part of what we are doing. It's not just do they understand the actual role and responsibility, but are they acting expeditiously? Is the legal system treating these cases with priority so that they are moved to the top of the queue and so that the child can be returned promptly?
I'm not sure what the time is. The clock doesn't seem to be working, but I yield back the balance of my time. Thank you, Mr. Chairman.
Thank you very much. Ms. Manning?
It can be very dangerous if the clocks are not working. Thank you, Chairman Smith and Ranking Member Wild, for bringing this important hearing, and I want to thank our witnesses for your service. Many years ago, I had a law partner who was able to use the Hague Convention to get an abducted child back home, returned to this country for her client. So I know the process can work when dealing with a compliant country to resolve this kind of a tragic situation, but sadly not all cases work out that way. Ms. Bernier-Toth, can you share more about what happens when state is made aware of a potential child abduction case? And are there things that we in Congress can do to be helpful?
Thank you for that. Typically, it starts when a parent or somebody on their behalf contacts the Office of Children's Issues to report that their child has been abducted to a Hague or a non-Hague country. The country officer in the Office of Children's Issues who's responsible for that particular country will talk to the parent and explain what their potential options are, whether it's a Hague Convention case, whether it's a criminal case, because it's up to the parent ultimately to decide what they choose to do. It's their child, and they are best placed to decide what their path is. Should they seek return of the child under the Hague, the Office of Children's Issues will facilitate and assist them in filing that application with the Foreign Central Authority. They can also go directly to the Foreign Central Authority, but that way we don't have as much visibility on the case. From then on, it's just tracking the case through, making sure that it's being handled as appropriately as it can be. In non-Hague cases, obviously, that's more complex because the options for the parent are more limited, and often it's a very difficult process of navigating the local government or the local legal system in the foreign country. So I hope that answers your question.
It does. And are there any commonalities among cases that are successful that you can share with us? And does congressional involvement at any particular level seem to be productive in resolving these cases?
That's a very good question. I think what you see, as you noted, when it works well because it creates that bridge between legal systems and it looks at habitual residence and not other custody issues. And so we do have partners where the convention works. And I think in that case, it then also serves as a preventive measure, because if a parent knows that if they abduct their child, the child will be returned to the habitual residence, then they don't hopefully abduct their child in the first place. Congress plays an important role. I think as was mentioned before, as CODELs go out, it's really helpful for for the host government to understand that this is an all-of-government issue. This is something that Congress cares about, that the State Department cares about, that other agencies care about, because ultimately it is about the children, and we have a responsibility to protect them.
Well, I think I appreciate my colleague, Representative Wild, raising that issue, because there are many of us who go on CODELs to Japan and to Korea. So if those issues, I'm glad to hear that Japan is doing better, but with regard to Korea, there are opportunities for us to raise those issues if we are continually made aware that there are problems in a particular country we're visiting. Do you find that there seems to be any kind of a cultural bias in returning, for example, a child to the father when the abducting parent has been the mother, or vice versa? And if so, how can those cultural biases be overcome?
So I would say that that is sort of country-specific and cultural-specific. Sometimes it's biases about returning a child to the father. Sometimes it's about returning a child to the mother. Again, our point when we work on these cases with the parent is that it's about the child. And we know, as Congressman Smith said, you know, separating a child from one of the parents by the unilateral actions of another parent is very traumatizing for the child. And that, I think that's where we try to focus and make that point, because ultimately it's not about culture, it's about the child and the child's welfare and best interests.
So you mentioned, I think, during your remarks that there are sometimes indications that can be spotted of likely abduction with a military family. Can you talk a little bit about that and what can be done to be more aware of that situation?
This is a major effort that we are undertaking, is to work again with the military officers, the community officers, to help them to raise their awareness of what some of the red flags might be, so that they can try to prevent and counsel their clients against taking actions which at the end will only be detrimental to the child. So there's an outreach program, there's a training program. We send teams out a couple of times a year to countries where we have significant numbers of U.S. military. We've had some success. Not only have they gone to Korea and Japan and Italy, but when they've done that kind of training, they've actually then used virtual platforms to bring other bases and other officers from other countries in as well. So it's a really major effort on our part.
Let me ask one final question. I don't know, because I also don't know whether my time has run out, but with regard to the 2024 annual report and also the letter included in our materials from Secretary Blinken, it is clear that Poland and Montenegro have just been added to the list. Can you tell us what happened, and are there things we can do to be helpful with those two countries?
I don't have the specifics on that in front of me, but I can tell you what happens is, as part of the annual review and the assessment of countries, this is a year-long process that we look at what's happening in that country. We evaluate the country's performance against the criteria laid out in the Goldman Act and make a decision as to whether we should cite them or not. This is something that's done in collaboration with our regional bureau, with our embassy abroad. But again, it is based on the criteria that are laid out in the Goldman Act. In terms of the numbers, in terms of the central authority operations, judicial processes, and things like that. Each country is going to be rated on those criteria.
Thank you again for all your hard work. I know these are heartbreaking situations for families, and I'm sure that the help you provide is very much appreciated. With that, I yield back.
Thank you. Dr. McCormick.
Thank you, Mr. Chair. International parental child abduction. It's a terrible thing. Since 1994, over 30,000 children have been abducted and taken abroad by one of their parents without the consent of the other. As a father, I can't fathom the terrible feeling of separation and heartbreak that those parents must endure. I would feel if my children were abducted, I could only imagine what they're going through. I applaud the work of Chairman Smith and what he's done historically in passing the Goldman Act 10 years ago, and his continued work to secure the child's future and to protect them from this grievous occurrence. Ms. Bernier-Toth, as you mentioned in your testimony, prevention is the best method of combating international parental child abduction. The Goldman Act created the Children's Passport Issuance Alert Program to notify the concerned parent if someone attempts to get their child a passport without their knowledge. You also mentioned just in this hearing, as I've been listening, that this is about the child. How many single parents have brought children across the southern border in the last 4 years?
I'm sorry, sir, I don't have that number.
I would say it's tens of thousands, just based on a thumbnail approach. How many of them had passports? Probably don't know.
I don't know.
Gotcha. When we used to test to see if children were related to their parents as they came across the southern border, we had about an 8 to 9% failure rate, from what I understand. We stopped testing. So my question is, if this is about children, like you say, which I do, I believe that too, it's about the child. If we don't know how many kids, by the way, we have tens of thousands of kids who came across the border by themselves. And by the way, we lost them. We don't know where they are right now, under the government charge. But it's about children. We don't know where those tens of thousands of children who came over here by themselves are. We don't know if those children were kidnapped by their single parents who brought the children across, because we don't know. And we didn't test. And finally, we don't even know if those kids being brought by that one person are genetically related to the person they're bringing across. So not only do we not have accountability for the children who came here by themselves, tens of thousands lost, we don't know if that child has been kidnapped by their single parent that's coming across the border with those kids. We also don't even know if they're related to that child and they're kidnapped from both parents. So how are we making this about the child? How do we have accountability in our own country, let alone foreign countries?
Sir, I really can't speak to issues that are related to the Department of Homeland Security and its responsibility for the southern border. I do know that we do have cases in the Office of Children's Issues of children who are brought into the United States from Mexico or across the U.S.-Mexico border, whether it's from Mexico or other countries, and where the left-behind parent has filed a Hague application or another application for the child's return. I don't have the numbers, but there are cases where we are aware of those the situations.
I would suggest we have almost no accountability. First of all, we know we don't have accountability for the tens of thousands of children who disappeared when they came across the border. We have no accountability because we have no idea how many single parents come here at the behest of one parent, not both, because you don't know and I don't know, and we have an act that says we should know. This isn't about law, because we have good laws. We just don't enforce them. And what I really want to make sure that people understand is we should make it about the child, but we're not. We have put politics ahead of children repeatedly in our own country, and so therefore it is absolutely obscenely hypocritical that we talk to other countries about not doing their part, when we in the United States are not doing our part. Shame on us. Shame on this administration. Shame on us for not following the law and not being accountable for the very children we're supposed to be protecting. And with that, I yield.
Thank you very much, Doctor. Ms. Jacobs.
Thank you, Mr. Chairman. Thanks to both of you for being here to testify on this important topic. As we all here know, the Hague Convention is an important tool to protect the lives of children both globally and domestically. And I know one of my constituents, Astrid Johnson, is watching this hearing today. 3 years ago, the father of her children fled to Dubai and seized all communications with her. She's not had contact with her 2 young children since June of 2023. And currently, she's unaware of their address and whereabouts, and they've moved several times. I know that you are working diligently on this case. We've had many conversations on this, but I want to talk about some of the constraints that stand in your way. In particular, the fact that there are some countries like the UAE who haven't signed on to the Hague Convention and are less cooperative. So I was wondering, how do you approach international child abduction cases when it comes to these less helpful countries and countries that aren't party to the Hague Convention, and how should we in Congress be thinking about that piece of this puzzle?
Thank you very much for that. When I am speaking with foreign government officials, especially those in non-Hague countries, again, I make the point that I made earlier, was that this is about the child. And this is a child who, in many instances, is both a U.S. citizen and a citizen of the host government, and that we have a collective responsibility to do right by them. And that does resonate often. In countries that are not signatory to the Hague Convention, we seek to have regular meetings regular discussions about individual cases and the overarching issues that are creating challenges for left-behind parents in trying to gain the return of their child or even just access to their child. And that is what we seek. Again, as I mentioned, we have an MOU with Saudi Arabia that lays out a specific time frame for meetings and issues that we will discuss. I think that's a model that we are trying to pursue with other countries as well. Because it means that we open up a dialogue, we understand each other's, we understand where the challenges are, we can be very frank in where we see the challenges, and we can look collectively at ways to try to address them.
Thank you. And, you know, we know there are a number of these countries that show a pattern of non-compliance. The 2024 annual report on international child abduction reports a number of them. The UAE is on that list. Unfortunately, while you have been successful in some of these cases, they do often take a very long time, sometimes several years, such as Ms. Johnson's case. So how would how should parents of internationally abducted children in these kinds of countries that are on this list engage with the State Department and relevant governments and raise awareness for their children? Like, what advice do you have?
That's an excellent question, and I hope that some of our parents who are here can answer that as well in the next panel. You know, I've seen some parents conduct really successful awareness campaigns that not just got the attention of the host government in a constructive way, but also elicited both sympathy and support from civil society in that country, many of whom may have been facing some of the same challenges themselves, depending on local laws. But I've also seen where those kinds of very public campaigns can be detrimental, can undermine efforts. So I think it's important that parents consult with their attorneys, with trusted advisors, sometimes other parents who've gone through the same kind of ordeal, to see what's going to work in this country, in this circumstances, given the circumstances of that particular case. But I have seen parents run very effective strategies to raise awareness about the pain that they have experienced, about the trauma to their children, and have gotten governments to pay attention, including our own.
Well, thank you, and thank you for both of you for all of your work on this issue. Mr. Chairman, I yield back.
Thank you, Ms. Jacobs. Just one final brief question. When we were writing the law, I put a section in there about reporting to Congress, Senate, House, individuals, when an individual who's had an abduction, if they give the consent, to let that member of Congress know so they could become activists on behalf of their cause. It is the law, Section 104, as long as the consent is given by the left behind parent. Is that being implemented?
Yes, sir, it is.
And do you have any idea how many members of Congress have been notified?
I don't. It's always at the behest with the agreement of the left behind parent. But, you know, again, I would assume that many left behind parents would love to have their member of Congress involved.
Right. But do they know that, I mean, some people have no idea where people they should call. When they call the Office of Children's Issues, do you let them know, as long as they give their authority, their consent, their member, House or
Yes.
Senate or both, can jump in?
Yes.
Okay. If you could get back with any kind of number on how often that is actually used, because I'm not aware that my office is, I mean, we get lots of requests, especially from out of the state and out of the district, but some from within. And I don't know of any, and maybe I missed it, that came from state where you know, you said this person wants you to get working on this. So please let us know.
It is standard procedure that the officers in the Office of Children's Issues will ask the parent if they want us to contact the member of Congress's office, but we can get back to you on that.
I'd appreciate that, because I think I mean, we have a lot of very effective people, both sides of the aisle, who know how, and when we talk about delegations, traveling, you know, you bring your names with you every time, especially from your own district or state. So it's a tool that I think needs to be used very aggressively. I thank you for your testimony and look forward to working with you going forward. I'd like to now welcome our second panel to the witness table, beginning with Jeffery Morehouse, who is Executive Director of Bring Abducted Children Home, a nonprofit organization dedicated to the immediate return of internationally abducted children being wrongfully detained in Japan. BAC strives to end Japan's human rights violation of denying children unfettered access to both parents and works to increase public awareness through outreach on the crisis of international child parental abduction. He is also founding partner of the Coalition to End International Parental Child Abduction, uniting organizations to work passionately to end and cooperatively to end international abduction of children through advocacy and public policy reform. Mr. Morehouse is an award-winning filmmaker, advocate, and has consulted and co-authored U.S. Department of State publications on international child abduction. We will then hear from Nafeesah Ali Ismail, who is an adult survivor of international parental child abduction. At the age of 7, Ms. Ali was abducted by her father from New Jersey to northern Egypt, where she remained for the next 10 years. She returned home in February 2021 and has dedicated her life to helping other children and young adult survivors of international child abduction. In 2024, she was appointed as Youth Ambassador to iStand Survivors Network, an NGO that is dedicated to empowering youth survivors of parental child abduction to provide support, resources, and a safe community for those who have experienced the trauma. Then we'll hear from Melissa Kucinski, who is a lawyer and mediator based in Washington, D.C. and New York. Her practice focuses exclusively on international family law, a large portion of which is international family abduction. Ms. Kucinski has trained judges on the Hague Convention in Maryland, California, Florida. She participates on U.S. delegations to the Hague Conference on the 6th Special Commission, a meeting on practical operation of the Hague Abduction Convention, and to meetings in Tokyo, Japan in 2014 to advise on the implementation of the Hague Convention. Ms. Kucinski has served on multiple delegations to the Hague. She teaches law at George Washington University School of Law and has authored several handbooks and case books on this subject. I'd like to now yield to Mr. Morehouse.
Thank you, Chairman Smith, Ranking Member Wild, and to the subcommittee for inviting me here today to share my expertise and personal experience in the ongoing crisis and crime of international parental child abduction. I request that my written testimony be entered into the record. Thank you. Over the past 14 years of advocacy for others and my own personal effort to locate and reunite with my kidnapped son, Atomu Imoto Morehouse, I've been told when our children are adults, they'll be free to contact us, the seeking parent. I understand the general public and the government are trying to offer kind words of support. These naive words dismiss the opportunity to engage and do more for the 30,000 American children that have been kidnapped to a foreign country since 1994. Victims of international parental child abduction do not magically reunite with their seeking parent when they become adults. They've been indoctrinated for years by the abducting parent in the myths that become their reality. Reunification staff at the National Center for Missing and Exploited Children have shared with us at conference that abduction victims are taught by the kidnapper that the other parent is dead, didn't want them, is dangerous or harmful toward them, or in the case of an abducting mother, they can be told, I don't know who the father is. All designed to erase the desire to seek out your other parent. The Supreme Court weighed in on this. They recognized that family abduction is a form of child abuse with potentially devastating consequences for a child, which may include negative impacts on the physical and mental well-being of the child, and may cause a child to experience loss of community and stability, leading to loneliness, anger, and fear of abandonment. The impact on this crime on victims is lifelong. In an article in the Sydney Morning Herald, Susumu Wataya bravely shared his experience. He said he was beaten when he asked about his father. His last name was secretly changed, cutting him off from all future contact. He said, and I quote, I lost my identity. The pain that this Japanese system causes children is beyond description, end quote. Last fall in Japan, I met Anthony Soma, a 26-year-old man kidnapped to Japan from the US when he was 7 years old. As a child, he was told by his mom that he told his mom as a child that he wanted to see his dad. She would get angry at him or yell at him. So he gave up asking. 3 years ago, he started asking questions about the stories he was told about his father. He said he wants to have a relationship with both parents without the conflict. Our children are trauma survivors, and that trauma doesn't stop when they become an adult. There should be no more survivors like Anthony Soma who are concerned about the conflict when they want to know both parents. There should just be love and support that assists the child to reunite. Mr. Chairman, on April 11th, 2024, you handed that letter, and you mentioned it at the beginning of today's hearing, to Japanese Prime Minister Kishida Fumio. And thank you again for that. Following his address to Congress, and you wrote, quote, "To date, more than 500 American children have been abducted to Japan by one of their respective parents and remain separated from the American parent. These abductions often occur against pre-existing court orders and in some cases with the passport assistance of the Japanese government. For the sake of all the children who are suffering and for the sake of U.S. and Japanese relations, I seek your public commitment to reunite these families. The U.S. Congress has been united and outspoken on these issues for years, urging your government to work to return American children," end quote. At the May 22nd, 2024 hearing in the Foreign Affairs Full Committee, you also asked, Mr. Chairman, Secretary Blinken about the 500 American children kidnapped to Japan. He answered, and I'll quote again, "On child abduction, I am seized with this. And when we have countries that are not abiding by the Hague Convention or engaging in practices that are keeping children away from their parents, that this is something we take action on. And I always welcome working with you on that." I'd love to learn what that action is. I haven't seen anything of substance to address this ongoing human and family rights crisis. If it doesn't result in demonstrable increase in the return of minor kidnapped children and the reunification of all American kidnapped children to or within Japan, regardless of age, it's all just words, words, words. Last month, U.S. Ambassador Rahm Emanuel tweeted an acknowledgement of the 10th anniversary of the Goldman Act. In it, he announced, quote, "Working together with Japan, the United States is focused on reuniting children with their left-behind parents and supporting families affected by parental child abduction." Are they praising Japan? Is there some kind of new secret plan to actually reunite and support families? Or are they just making an unaccountable statement? Carefully, carefully crafted words. We need actions that lead to results. Japan took action for the families of the 17 Japanese citizens kidnapped to North Korea between 1977 and 1983. The past 3 U.S. presidents have met with their families and made statements of support to the press. On April 18th of this year, the Associated Press reported that U.S. Ambassador to the UN, Linda Thomas Greenfield, met with 5 relatives of these abductees and told them, quote, "The United States stands with these families, with all of Japan, and with the international community in pressing for a resolution that would allow all families separated by the regime's policies to be reunited. She furthered, "I'm all too familiar with the pain and loss and the suffering that you as family members are experiencing. I know how painful this is for you, and then how long you have had to endure this pain. I understand enduring pain." These seeking parents that are here today behind me, they understand enduring pain. Seeking parents from all over the globe that are watching this hearing right now understand enduring pain. Our children, cut off from knowing their families, understand enduring pain. Who is going to take action to end our unnecessary pain? Unless Japan wants to continue to be internationally known as a black hole for child abduction, it is long past due for their government to show good faith and publicly commit to reuniting and returning our children. There must be lasting public commitment from the US government that we will continue to help their families, and that's really important, but Japan must help ours. Full support needs to come from the government of Japan to locate, fund, and provide for the reunification of our kidnapped children with their seeking parents. This should extend well into adulthood. Trained experts who understand the lasting damage of parental child abduction need to be available to assist seeking parents to bridge the gap and the barriers created by the child's kidnapping and hardened by time. The years and years these families, myself included, have had and our children. It's estimated in Japan 150,000 children per year, that's 3 million over 20 years, are victims of loss of access to a parent. This reunification program should also include American parents who lived there and were robbed of parental rights due to Japan's single custody laws. Now, you may have read, and actually, Chairman Smith, I think you mentioned also, and some of the first panel witnesses talked about Japan fixing their single custody system in the laws in an amendment earlier this year, and it was due to international and domestic pressure. They didn't fix it. Under the 2024 amendment to the Civil Code, joint parental responsibility would be an option in the future if both parents agreed. They could do that now. They could work around the existing system and share. If they don't agree, a judge could order it, but it's not written into the law to break from years and years of precedents to make joint parental responsibility a new standard. It's going to take 2 years to implement, meaning it's not going to take effect until April of 2026. After that, they're going to do a 5-year observation period. So now we're into 2031, until there will be some sort of formal review of its effectiveness or actually ineffectiveness. And I've confirmed all of these facts with a Japanese member of parliament, Umemura Mizuho, who has worked on this issue from within Japan for years. So there hasn't been a change as it's been reported sometimes in the press, or, and I'll take exception to the first panel, how it was represented in some of the testimony. The US government designated Brazil, India, and Japan as top 3 worst offenders on international parental child abduction. Our coalition partners at Bring Our Kids Home have pleaded with both the US and Indian governments to establish a joint intergovernmental working group to examine cases and promptly repatriate victims to their countries of habitual residence. This would allow competent courts in both nations to make custody determinations in accordance with the best interest of the child. The government of India, they have been non-committal at best. While the US continues to urge counterparts in India to accede to the Hague Abduction Convention, India has thus far refused to do so. And if they do become a Hague signatory, I am extremely concerned that all of these existing cases will be left behind again, just like happened with Japan. As we've seen it unfold when Japan became a signatory in April 2024, all of the seeking parents were barred from filing an application for return under the convention. We were only allowed to pursue access. The State Department's interpretation of the Goldman Act, 420 children were excluded. And I know they talked about open cases in that year, but I've been around long enough, unfortunately, that I saw hearing after hearing where they reduced the number of cases in their testimony to hearings that you chaired, until they finally claimed there were only 50 open cases on that first report. There were 420 children that they have acknowledged that were kidnapped to Japan prior to that time. These cases were excluded from determining Japan's noncompliance. We must not allow this to happen again when India, if they eventually accede, or any other country going forward. Abduction cases from the United States to India, they continue to just languish. Hope for victimized American families and children has all but disappeared. The US government's lack of an effective systemic response and the State Department's particular failure to utilize escalating and meaningful actions under the Goldman Act and hold the government of India accountable continue to inflict pain and suffering on a daily basis to American victims of IPCA. Argentina, Brazil, Ecuador, Egypt, India, Jordan, Peru, Romania, and the United Arab Emirates have all been cited for noncompliance under the Goldman Act 8 or more years since 2014. Costa Rica and Honduras, 6 times. Bahamas, Dominican Republic, 4 times. Belize, Guatemala, Japan, Lebanon, the Republic of Korea, Tunisia, 3 times. 15 other countries have been cited 1 or 2 times. How many tools provided by the Goldman Act have they used? 1, a démarche. Although at the hearing you mentioned there was one other tool used, news to me, I'm glad they moved on once, but they've used 1 year after year after year, a letter. They've sent 159 of these over the past 11 years. When Congress, just like you did today, questioned them about their usage of the tools or lack thereof, they respond that each tool is carefully considered, and then they choose the best tool for that country and situation, and then they send another démarche. Dr. Jae Sung, whose son Brian was abducted in June of 2019 to South Korea, and Mike Fallon, who a couple of members talked about today, whose son Michael Jr. was kidnapped there in August of 2023, shared their experiences with me prior to the hearing. The Korean government, a Hague signatory, sees these cases as family matters and refuses to be involved. When they're asked to take action and enforce returns, they blame the enforcement officers for their failure. And in doing so, Korea allows the abductor to prolong the ongoing child abuse and the seeking parent's suffering. The underlying message is give up and go away. We are not giving up on our children, and we are not going away. What can we do today to address some of the problems I've outlined? Represent. Co-sponsor H.R. 8365, the Sean and David Goldman Amendments Act. Get it through committee. Get it to the floor. Section 2, paragraph 1 redefines abduction cases so that it's any case reported involving an application with the central authority to the United States or directly with the foreign central authority by a seeking parent seeking the rights of access or return so that no case is forgotten and left behind again. And this also is very important. It addresses a statutory order argument that state made for years on why they've excluded access cases like Japan and 13 other countries. Access cases are abduction cases. They should not be included from the reporting when determining noncompliance. Section 2, paragraph 2 is very important as well. Right now, they are required to report to the Foreign Affairs and Foreign Relations in the Senate. It would expand reporting to Justice, which has a stake in this, Homeland Security, which has a stake in this, and Appropriations, which certainly has an important role. Under the original act, there was money written into it for judicial training. It never got appropriated. State could never train judges in family courts across the country. When I've been in court as an expert witness, I have to spend half my time trying to explain the annual report to the judge so they have a fuller understanding of the real risks with the country in question. Section 2, paragraph 3 updates and changes the age of majority to 18, which is what it should be. That's the age of majority in this country and most of the world. Section 3 would require the diplomatic mission to do outreach to the victims starting at age 16 and continue. Let them know that they're an American citizen and they have certain inherent rights. This would continue annually unless the victim, once an adult, requests it to cease. The first time they make that contact, it's not necessarily going to break through those years and years and years of psychological hold and mythology, but they have a right to know they have certain inherent rights and services as a U.S. victim and as a crime victim. And importantly, Section 4 would call for a study of the grave, grave harm to abducted children and left behind parents as a result of IPCA. The Supreme Court recognized the devastating consequences of family abduction. The Senate has adopted multiple resolutions citing the harm done by IPCA. DOJ published a family resource guide on international parental kidnapping in 2002, last updated in 2007. They also updated a specific law enforcement guide on international parental kidnapping in 2018. There's a need for a study of the grave harm to the children and the seeking parents in this process. 30,000 U.S. children kidnapped to a foreign country since 1994. That's the size of an average American town, and it's just disappeared. When will we see significant actions and a whole of government approach to prioritizing families and preventing future abductions? Thank you.
Thank you so much for that very eloquent and powerful statement. Ms. Ali.
Good morning, Chairman Smith, Ranking Member Wild, and members of this distinguished committee. My name is Nafeesah Ali Ismail, and I'm an adult survivor of international parental-child abduction. I sincerely thank you for the opportunity to share my story and relate the lived experience of other children and youth survivors, those who have come home like me and those who still suffer and remain abducted in foreign lands. 3 years ago, I came home from a 10-year abduction to Egypt. At the age of 7, my father took me from my birthplace in Newark, New Jersey. I didn't understand that when I left New Jersey, I was leaving my family, my language, and all that I had known in my young life. My father then decided to move to Egypt, and we never came back. Instead, I remember settling in a small village in northern Egypt where everything was foreign to me. In the early days, I was not directly taught Arabic language, but I was able to pick up the Egyptian dialect pretty quickly. Soon I was able to comprehend how people spoke about me. It was challenging and confusing for me to understand why I was the child with horrible skin tone, that relatives slathered with whitening cream, and also continuously straightened my hair. My father enrolled me in a language school, and even as a 3rd grader, I was able to pick up on the poor quality of education offered to me. The school helped me speak Arabic, but the academic quality was lacking in other aspects. Regularly on my way to school, and people in the village stared at me loudly asking, "Why is she so dark?" I can never forget those days. I was too young to understand. Yet I understand perfectly that I didn't belong there. When I wasn't in school, I mainly stayed in my room imagining someone from the United States government would knock on a door and ask for me. I know other survivors like me had this silly dream. I became depressed and lost hope that I would return to the United States and attempted suicide multiple times. As the years dragged on, altercations between me and my father grew more frequent. After one serious altercation, I decided that I had enough and reached out to my mother, whom I was able to maintain some contact with. In the beginning, my mother tried to bring me home. She appealed to the State Department, but she was told that she had to get an attorney and court orders. She was also told to work with Egyptian officials and my father to resolve the matter. She didn't know how to do that. Thankfully, my mother introduced me to Dr. Noel Hunter and iStand Parent Network. We communicated over several months while she understood my situation, and we planned how I could get out of Egypt. And honestly, at this point, I had lost hope that I would come home, but I went along with the process. Then in December 2020, our plan gradually turned into action. First, I arranged my mother to send me money to one of my friends, since I had no bank account and no Egyptian identification. I also took a chance by arranging for my online boyfriend, whom I never met, to meet me and take me to the safe house in Cairo. Immediately after receiving the money, I told my father that I had tutoring classes. In reality, I went to go buy a new SIM card so no one could track me. I brought a new outfit so no one would recognize my clothes. And after packing my backpack and getting ready to leave, I asked my father for a hug before I left. He told me to wait until I returned from class because he had a surprise. This broke my heart and made me feel guilty. After all, I was leaving. I boarded a microbus to Mansoura to meet up with my online friend. From there, we took a taxi, and after 3 hours, I arrived at the safe house. I still remember the fear and relief I felt that day. I also believed in just a few days, I'll be going back home with Dr. Hunter. But this was not the case. To begin with, we went to the US Embassy in Cairo to request an emergency passport. It took 2 weeks, 2 trips to the embassy, and special forms from me and my mother to get the passport issued. During this time, my father started calling the embassy, making threats, demanding to know my whereabouts. The embassy told me that they declined to offer any information about me as a US citizen. I was still scared that he would find me. We soon learned that having an emergency passport was not enough for me to exit Egypt because I didn't have proof of any Egyptian identification. It was arranged for me to go to the Ministry of Administrations of Passports, Immigration, and Nationality in Cairo to obtain a foreign residence card. I visited the location on 4 separate occasions. The staff was uncooperative, leading me in circles and ultimately denying my eligibility to obtain a foreign residence card. During this time, we repeatedly asked the US Embassy to intervene. They said they made some calls to explain my situation, but they only kept referring us back to the ministry. For the longest time, we got nowhere, and I was disillusioned. Finally, the women who operated the safe house understood how to navigate the complex Egyptian system and found a loophole for me to obtain my Egyptian identification. I was able to get a foreign resident card in February 2021. Dr. Hunter immediately booked a one-way flight to New York City. I'd like to point out that at the end, I came home with the help of brave women. Only limited support from my government, and in the end, I saved myself with the help of others. But what about children who are much younger than me, the ones who don't have advocates or have a safe house? Returning to the United States as a 17-year-old who lived most of her life overseas and still is challenging. Being on the verge of turning into an adult was terrifying because my family did not show much support or guidance when I returned. My older brother helped me enroll at St. Benedict's Preparatory Academy for my last high school years, which helped me prepare for life after graduation. I'm now a college student, and I'm learning how to navigate life. It's not easy. It's been 3 years since my return, and I am grateful to be back home in the United States. I have experienced a lot, learned many things, and grown tremendously. but the way I return makes me feel out of place. This brings me to my recommendations. Our government must be more proactive in preventing children like me from being abducted and prioritizing our return from foreign countries and providing a support system for us when we do come home. When we do come home, please help us have a soft landing after such a long, painful time of separation from our family members by funding a comprehensive aftercare program from the moment we step off the airplane. An aftercare program that involves counseling, temporary financial support, education support, and opportunities for connecting and healing with other survivors. I know for a fact that such aftercare support works because I have experienced it through iStand. They have helped me ease my transition back into normalcy, introduced me to other youth survivors, took me to Washington, D.C., invited me to summer camp, and now have appointed me as a youth ambassador. At our summer camp, I met survivors like Dexter, Maya, and Liam. I also met Mio and Amani, who are with me today behind me. We hiked, we swam, and we ate our meals. We laughed and cried and shared our experiences together in a therapeutic community. We stayed in touch through WhatsApp and regular check-ins. Another survivor, Elisa, who's also here today, she's representing her sister and her brother, Layla and Yusuf, from Lebanon. As one of the oldest youth survivors in our group, I feel a special obligation on their behalf, as I'm doing today, in a sense. I rescued myself from abduction. Now I want to rescue other abducted children, help them have a soft landing and long-term unification support that they need when they do return home. I'm asking Congress, and especially members of this committee, to fund a long-term aftercare initiative for abducted survivors and turn oversight into action to bring abducted American children home. Thank you.
Ms. Ali, thank you so much for that amazing testimony. Thank you for your courage and your tenacity. And you are an inspiration to other abducted children that there is hope. So you have blazed the trail. Thank you so very, very much. And Noelle Hunter, thank you for your great work, as always. I'd like to now, Ms. Kucinski, the floor is yours.
Thank you. Chairman Smith, Ranking Member Wild, and members of the subcommittee, thank you for inviting me to participate in today's hearing. And I thank my co-panelists. My name is Melissa Kucinski. My comments today will summarize my written statement, which I've provided for the record and for your consideration. Thank you. For U.S. lawyers, the most visible part of the Goldman Act is the annual report on international child abduction. The report's conclusions are routinely relied on in litigation of custody cases where a parent expresses a fear of parental child abduction. But in reviewing this report, there are shortcomings. The report misses cases that are not filed through the central authority. It classifies cases as successfully resolved when a parent may have otherwise abandoned their attempt to seek their child's return. Some countries' compliance is based on so few cases that it could be misleading. And the report conflates countries having international legal obligations to return children to the United States with those that do not have such an obligation. The Hague Conference on Private International Law also collects data which paints a more accurate and comprehensive picture. Using its most recent statistics from October of 2023, we see that Argentina, for example, averaged 218 days to resolve a case under the convention. The 2024 U.S. report classified Argentina as not compliant. In comparison, Australia averaged 309 days, according to the Hague Conference statistics, but is compliant in the U.S. report. Poland, as another example, averaged 250 days, according to Hague Conference statistics, and is not compliant in the U.S. report. The United States, from its own reporting, averages 253 days to resolve a case. The length of time to resolve these time-sensitive cases is but one factor in determining compliance, but it's an important factor. and the raw data provided by the Hague Conference could indicate a different result than reached by the US report for some countries. Overall, the 16 non-compliant countries that are on the current US report are chronic designees, with 10 having been cited multiple times since reporting began under the Act. The reporting and the Act itself does not appear to be motivating a change in these countries. Therefore, I make the following proposals. First, courts in the United States take significant time to resolve abduction convention cases. The United States should be the gold standard in resolving these cases, which will then better enable the Department of State to represent the value of quickly and capably resolving these cases when they're discussing these matters with other countries. In that regard, there should be more resources devoted to educating our judges and designating a judge in each courthouse to handle these cases. There should be more resources devoted to educating American lawyers, including those who are members of the attorney network established by the Department of State. There needs to be more accurate and comprehensive statistics and more factual data about
So we will have to leave momentarily, but each of your testimonies were blueprints, in terms of what didn't happen in Ms. Ali's case, and how we need to rectify that. And I will personally get your oral as well as written statements over to our two panelists in the first panel. I would have hoped that they would have stayed to hear you because it is so powerful and so compelling, all three of you. But you have given us a roadmap. Where do we go now? And I thank you, Melissa, for those thoughts. They are really, really good. And of course, Jeffrey, you've been giving us insights from the very beginning, so I thank you for that. And we'll take everything you've recommended and act on it to the best of our ability as a committee, as individuals, because we care deeply about this issue, what you have endured. And again, Ms. Ali standing up for all of the other children, which is a perspective that we have not really had enough focus on years to date, so I thank you for that. When you said that you had fantasized about the U.S. government rescuing you, the government did not. It failed you. Our government failed you. That's awful in the extreme. So that can't happen. And of course, Jeffrey, your child. It's just we just need to step this up. Again, I think sanctioning is something they've got to matriculate from admonishing and sending out demarches to. We're not kidding. And that's going to be my battle cry going forward on behalf of these children and adults, the left behind parents. So I thank you from the bottom of our heart. We're going to keep pushing. We'll get those other amendments passed. We're trying hard right now. And I'd like to just yield for a final comment from mine.
Thank you. Thank you, Mr. Chairman. I concur in everything that the chairman has just said. And I want you to know that just because we have not asked you questions today, please do not feel that you have not made an impact. You've made a huge impact on us and the work that we will do going forward. Speaking for myself, I will remember you, Ms. Ali, forever, and you will help guide the work that I continue to do in this area. I do want to allow time for us to step down so that I can meet each of you personally, and I'm sure Chairman Smith wants to also, and the others in the audience. So with that, I do suggest that we adjourn, but I do want you not to feel that just because we haven't asked you questions, this hasn't been tremendously impactful. Thank you.
Thank you. The hearing is adjourned, and I thank you. Jeffrey.
If I could just request that parents and other NGOs that wish to submit statements for the record be allowed to do so.
Without objection, so ordered, please.
Thank you.
Oh, yeah, pursuant to the rules, of course, members may have 5 days to submit statements, questions, and extraneous materials for the record, subject to the length limitations. Without objection, the committee stands adjourned. And again, thank you again.